come before the court is Route 20 Holdings versus Stuart Hartman. All right, each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you wish to do so, let me know when you take the podium, and I'll do my best to try to monitor that for you. We have read your briefs, and we are ready to begin.
Please the court, my name is Barry Epstein, and I represent the appellant in this case, Route 20. And this case, Your Honors, is not a complicated case. This case is based upon a land contract that was entered into in 2012 by the then owner of the property in question, which was Route 20, it was Oberlin Land Trust. And they entered into the contract with the appellees, the Hartmans. At the time the contract was entered into, it provided for certain things. Among others was that the appellees were required to make an installment payment monthly and also to pay the real estate taxes that were owed on the property. That contract continued with the same vendor and vendees until the real estate was sold to the appellant, Route 20 Holdings, LLC, and they are the appellant in this particular case. After the land contract was sold, after the land was sold, the land contract was assigned to the new owners, the appellant in this case. When the appellant took possession of the property, they learned that the land contract had not been complied with. And as a result, an action to evict the appellees was filed in the Oberlin Municipal Court. And that was filed on August 17, 2018. Trial took place after the eviction action was filed, and testimony was taken at the trial. There really isn't a dispute as to what occurred at the trial. At trial, various exhibits were marked and admitted into evidence. Among those was a handwritten accounting of what the appellees alleged was paid on land contract. The appellees alleged that they paid some $57,000 towards the land contract, which was a $235,000 land contract, requiring them only to pay 20% to avoid an eviction, which would have been $47,000. However, when it came time to prove the payments that they made, they submitted canceled checks, and the canceled checks amounted to about $35,000. In addition to that, they admitted that they never paid any of the real estate taxes that were due on the land contract. My research indicated no case, other than the cases that say that when you're in a land contract and you are the vendees of the land contract and the contract requires you to pay the real estate taxes, the 20% of the purchase price is figured on the principal purchase price, and payments for real estate taxes must be subtracted from the payment that you make to determine how much you're paying on the principal. The same with insurance payments. You have questions, Judge? Okay. So in this particular case, the appellees admitted at the trial, and the trial transcript is clear, that they made no payments for real estate taxes, none. Testimony at trial from the original owners of the property who sold the land to the current appellant. He testified that there were no real estate taxes paid by the appellees, and in fact, he had to pay the taxes himself, and produced evidence of that, and I think it's Exhibit H, shows the amount of real estate taxes that he paid during the process of this land contract to keep the taxes current. So we were asked the trial court to subtract the real estate tax payments from the total paid by the appellees, assuming that they paid what they claim they paid, $57,000. And if you subtract the real estate taxes from that, the net payment towards the principal of the land contract is way less than the 20% that they're required to pay.
Counsel, did the trial court even talk about the taxes and its entry?
They did not talk about the taxes, Your Honor, and I don't, I'm not the trial judge, so I don't understand why, and certainly that was argued, and it was briefed to the trial court.
That was my next question,
Yes.
which you just answered. Thank you.
Yes. The other issue in this case, again, is not complicated. My research of the law indicates that payment is an affirmative defense. One cannot come into court and say, I paid it, without submitting some type of proof of payment. There is no proof of payment of $57,000 on the same installment contract. There is proof of payment of about $35,000. There's some additional checks that were submitted by the appellees that were duplicate checks of ones that are in that pile of checks submitted. And they also tried to submit check registers as indications of payment. As we all know, a check register means nothing. You can write anything you want on a check register. They did not produce any account statements for the checking accounts. In terms of why this wasn't discovered before the trial, as the judges know, I'm sure, these are summary proceedings. There's no discovery rules allowed in these types of proceedings. I mean, you file an eviction case, and it's set for hearing, summarily a couple of weeks after it's filed. And so the civil rules don't apply for discovery. So a lot of the discovery took place by subpoena to bring these things to court at the trial. So I guess the basic thing that we're arguing here is that, number one, 20% was not paid. If you consider the real estate taxes that the appellee should have paid that they didn't pay, and you subtract that amount from the $57,000 that they claim was paid, but on the other hand, they didn't pay $57,000 because they didn't submit proof of payment of $57,000. The land contract was breached about a month after it was entered into. There is no dispute as to that. The appellee testified at trial that they understood that they never made payments the way they were supposed to make it, and that that was breached pretty quickly. If you look at their exhibit, I think it's Exhibit B, and trial transcript, page 114, the appellee admits, Mr. Hartman admits, that it was breached almost immediately, that they never made it. I think there were 27 months that there were no payments made. And that was at the first 27 months of land contract. I mean, they just didn't make any payments. And then there were a number of other months, I think 17, where partial payment was made. So the land contract was basically breached pretty quickly into the process of this transaction with the original owner of the real estate. So we're asking the court to send it back to the trial court, at least so that they can subtract the payments made for real estate taxes from the payments that the appellees made, and to compute the payments the appellees made by looking at the exhibits that were admitted into evidence and calculating the payments based upon the exhibits and proof of what was paid, not testimony that I paid it, without anything further. Thank you.
Police report. I'm Stuart Hartman, representing my wife and I.
Mr. Hartman, I just want to make a record clear on something. You can represent yourself.
Oh,
We understand that you're speaking for your wife also.
Okay. My first point that I'd like to make is exactly what Mr. Epstein just said. We did not comply with the land contract within the first year of the contract. We ended up staying there and making payments for the 5 years prior to the sale of the property. At no time did any legal action get taken against us to either come current with payments, or the fact that we didn't make the tax payments was because, number one, he never sent us any tax paperwork telling us what the amount was. The other part is that perhaps, and I'd like to hear it or read it, I said a number of 57,000. I don't believe I did, because we have our records that show we paid around $83,000. The point with that I want to make is the company, Overland Land Trust, had a $235,000 contract and a promissory note covering that contract. In June of 2012, the property was, by paperwork, valued at $235,000. In March of March of 18, the property was only worth $140,000. Now that, to me, indicates that they were satisfied that we had paid $95,000. I believe we paid $82,000 or $83,000, but we did not get a $10,000 credit in January of 13, because if we had, we have no paperwork saying we got it. He, the representative of Overland Trust, didn't issue us any. He perjured himself by making the statement that Overland Land Trust had to, on several occasions, pay property insurance. And we proved that was wrong. We had all of the receipts from the insurance from late 12 to March of 18. When the property sold in March of 18, there was no mention of a land contract by either Overland Land Trust or Route 20 Holdings. And so for that reason, when the title search was done, nothing showed up to stop the transfer of the property. In August of 18, the land contract was signed over to Route 20 Holdings. And they started trying to use that against us. The one problem I have is I submitted evidence in my appendix to the brief, and for some reason it was stricken from the record. My appendix was completely stricken from the record.
Was that evidence submitted below at the trial court?
No.
We
No.
can only consider what's been at the trial court, and we'll look at that.
Oh, okay, well, this is my day in court, and I thought evidence was evidence. But I have 3 letters from Overland Land Trust, and I believe that the last one especially was totally fictitious. We received a letter on the 4th of December telling us we had to be out by the 31st of December. We got a second letter on the 17th of December, again stipulating that we needed to be out by the 31st. It also had attached to it a release that would release Overland Land Trust from anything against us, or that we think is against them, whatever. So that nobody be at fault for anything. And we did not sign that because each letter threatened to take legal action. And I believed that legal action was what needed to be taken. The final letter I got from Overland Land Trust was in February 7th. And again, in that letter, it stated we had to be out by the 31st of December. And that particular letter had initials of a lawyer. I don't believe that lawyer would sign a letter dated the 7th telling me to be out a month and a half earlier. But the fact that I believe is the most important is that Route 20 Holdings should not have this deed in their name. If that was legal, the way they did that sale, then my position is the same as it was stated in the court. Overland Land Trust never sent me a financial statement indicating what we had paid towards what. And there was no interest written into the land contract except for late payments. And at no time did Overland Land Trust do anything about late payments other than talk to me, telling me you gotta catch up, you gotta keep going. But no legal action was ever taken. The fact that he threatened legal action, I'm speaking of Overland Land Trust, I was waiting for legal paperwork to settle this land contract. We were not given an opportunity to settle the land contract by either Overland Land Trust or Route 20 Holdings. We have not yet received a statement with the breakdown of payments from Route 20 Holdings, and as far as I can see by the law and the court cases that we have been through, the only thing that has changed, even if that part of it was legal, the only thing that has changed is the owner of the deed. If he's instituting the land contract, why didn't he get the land contract? He knew there was one, but he didn't get it until months after, and that was after he had lost the case in court. I believe that we should be given the opportunity to satisfy the land contract for the $140,000 that it sold for in March of 17. To go along with not following the land contract, Route 20 Holdings has been collecting rent from our renters, and that it just isn't part of the land contract, and it's just wrong. So that money that he has collected, I believe, should be applied to the purchase price of the $140,000, and I believe that the $10,000 credit for having the property ready to rent in January of 13 should be credited, because it states in the contract that if the apartments in the house were not livable, ready to rent by the 1st of January, I would immediately owe them $14,000. They didn't ask for the $14,000, but they did say in court, again, the gentleman representing Overland Land Trust said in court that the apartments were not ready to rent. Again, I believe he perjured himself, but I believe that's all I have.
All right, thank you.
Thank you.
When Route 20 Holdings, the appellant, took title to the property and was assigned a land contract, there was a notice of forfeiture served on the appellees as Exhibit E, as in your packet. And that set forth the rights of the appellees to cure cure whatever defects were in the land contract. It says in Exhibit E exactly what the cure figure was. They didn't cure it. They didn't even try to cure it. They didn't even contact Route 20 Holdings to cure it. And you can read Mr. Hartman's testimony on cross-examination in the transcript, and clearly he indicates that they made no effort to do so, and that they made no, and he admitted the payments that he missed, and that the land contract had been defaulted. So Route 20 Holdings did what they were legally required to do in terms of asking the appellees to cure the problems with the land contract. The appellees didn't do anything. In terms of the real estate taxes, the person that testified on behalf of Oberlin Land Trust, the first owners of the property, who was the managing member of the LLC, produced canceled checks payable to the Lorain County Treasurer's Office, and they were admitted in evidence as an exhibit. And those checks, totaled, I believe, about $25,000 or $17,000. So, that had to be subtracted from whatever the appellees actually paid on a land contract, again, to compute to 20% of whether forfeiture could be done by eviction or whether a foreclosure would be required under the law. And again, the canceled checks submitted by the appellees and their proof of payment is basically about $35,000. And those checks are marked as exhibits. Unless anybody has a question.
All right. Thank you both for your presentations. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides, posted on our website and that of the Supreme Court.
Thank you.